News on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
That's us, WDXE, and it's time for Stan Pierchoski, then Bulletproof Estate Planning with your host, Stan Pierchoski. And I get to sit in on it. How about that?
It is time. Good morning, Jeff.
How are you?
Oh, just wonderful. How about you?
We were talking about it off the air. It's been a solid week since last Friday.
It's been a whole week. That's right. I mean, wow. Sometimes it seems longer, sometimes it seems shorter, doesn't it?
It does. Sometimes it kind of drags on, and sometimes it's like right here before you know it. So,
Well, I've had a pretty banner week, both professionally and personally.
Yeah.
Personally, I think I might have mentioned before, I had a grandchild on the way.
That's right.
And the grandchild was due December the 9th, which was, Thursday before last, right?
Yes.
And my wife went down. I can't remember the day she went down, but it was like almost 2 weeks before that. So it was in November. Okay?
Yeah.
I can't remember. She went down on the Thursday before. Okay, the child was actually had a due date, and when she had to do something here, so she couldn't leave till Thursday. And for a couple of days, she kept saying, "Boy, I hope she can hold out one more day."
Right.
So she flies, and my daughter lives in Florida, so she flies down to help her because she has a 2-year-old and wants to help out. Wants to be there for the delivery, right? Well, on it goes. Okay.
Yes.
And she gets, it gets up on the. No, I guess it was actually 2 weeks. So she was there almost 2 weeks.
Yeah.
And the baby never came. I mean,
oh my.
My daughter was. I don't know how all this works, but they had some contractions for hours, but they're never regular, and then they go away, and that's almost an everyday thing. And they're walking, they're eating the foods that are supposed to cause this thing to happen. They're doing everything they can because she was
ready.
She looked like a ripe melon. I swear.
She was so ready.
And she was pretty frustrated. But anyway, so I guess on Tuesday of this week, which come yesterday, Thursday, would have been 2 weeks she was down there. And she had to come back. She had something going on that she had to come back. So she said she has to come back Wednesday morning. Well, Tuesday morning, I get a text, and she says, and my daughter said, I think this is the day. She's been contracting all through the night and still in the morning.
Oh, my.
And then about a half an hour later, I get a text with a picture saying they're in the car. It says, we're on the way to the birthing center. It looks like we're going to have a baby.
Oh, good.
And so they did. And it was a big boy, 9 pounds, 4 ounces.
Oh, my goodness. Well, he had some extra growing time.
There you go. That's right. He's overdone. But he was born, and my daughter was a real trooper. She was in labor for I don't know what you count the stuff before, but she goes to the hospital. She gets here at 12:30.
Yeah.
I guess her water breaks at 12:45, and had the child at 1:38. So an hour and 8 minutes of actual that kind of labor.
Oh, my goodness.
But for the days and a couple of weeks leading up to it, she had dealt with those.
Oh, yeah.
Whatever those are things.
She was in pre-labor for several days.
Yeah. So anyway, the child came, and my wife got to be there for it. She still came home Wednesday, and we're going to head back there probably maybe the week between Christmas and New Year's. We're trying to figure it out. So, but she was a big help while she was there because her husband works. But now that the baby was born, he gets his vacation time, and he's there helping because, it's one thing to have the newborn, but then to have a 2-year-old that's there too. So. And all the mothers out there know what I'm talking about.
Yeah,
all the guys out there are like me, and they don't know what we're talking about. But I get it. I did. They were just real troopers about it, and real champs. And so I was proud. I was glowing on Tuesday. So I've seen a lot of pictures, but not seen. I've not had to hold the child yet. So.
Well, I understand a little bit about it. I do. I've got a fairly new grandbaby to us, and we're still enjoying it. It was at the house last night, as a matter of fact. So. Yeah.
And I hate that they're so far away.
Congratulations.
I hate that they're so far away, but thank you. Yeah. I often said, years ago, I said, I'm not real anxious to be a grandparent. I'm sure it'll be wonderful when it happens, but I wasn't real anxious for it.
Yeah.
People said, you can't wait to be a grandparent. I said, I can kind of wait. But anyway, once it came around, though, it does that to you, and you know what I mean. So, but again, whenever they come up and we go down, which is relatively often throughout the year, we get to see them. So
that's great.
Probably not, probably us going down there for a while because when you got a newborn, you want to wait a while before you start carting them around on airplanes. So anyway, that was a big day, and I was happy for my daughter because she was getting pretty frustrated. She was a week overdue, which the due date, I guess is just a good guess anyway.
Right.
So, but anyway, all is well. Mother and son are doing fine.
Good.
They sent her home, and
Good deal.
Yeah, so that was fun.
Good deal. Now,
Yeah.
have they named the baby?
They did. His name is her married name is Curry, so the baby's name is Luke Elliott Curry.
Luke Elliott.
Yeah. Good strong name.
I
Good
like
strong Christian name.
Good name.
Yeah.
Luke, good name.
Biblical name.
Yes.
Not Lucas, Luke. Yeah.
Luke. I like it.
Yeah, I do too.
I like it.
And his sister's named Lydia, so we got
Lydia.
L and L. So
Yeah.
Anyway, but
Good
she's
deal.
a kick.
Good deal.
Anyway, that's personal stuff. Professionally, we had a pretty good week. We had one of our 10-care approvals come in. This was a real stubborn one, so we're kind of
Yes.
glad to see it.
Yes.
And it's still being a little stubborn. Company came in and they said, okay, we approve and we do this. But when they approve it effective a certain date where they go back to the filing,
Yes.
right?
Yes.
Well, the date they're going to approve it, they go back, is not what we wanted it to be.
Right.
So we may speak with them a few times and possibly appeal that issue of it, but the
Yes.
approval's in, so we're good. We got approval. That's great.
Yeah.
And again, really, the backdating it's not even for us. It's kind of for the facility because
Right.
they're the ones that's going to be affected by that.
Right.
So, but it was almost the way we wanted it, but
Yes.
which is typical with this kind of work. But we'll get there.
Yeah.
So
I've so many conversations with you, and this is somewhat personal too, but the folks that listen to me know that my father-in-law's recently been in the hospital. He's 92.
Okay.
And suffers with some health issues, and we were just in the hospital this past week, but he was dismissed yesterday, and we brought him back home. And of course, we're doing home health care with him.
Gotcha.
But as time goes on, I can see that we're probably going to have to. If he continues to stay with us, I'm not sure how long we can
Right.
care for him like he's going to need care.
Exactly.
And so we're wrestling with that. I know that my wife wants to care for him as long as we can, and we will. That's what we'll do. But all of these conversations that you and I've had have
Right.
made me think about, okay, what should we have done? Because really, we haven't done anything to prepare for what's going to happen. And of course, we're not in the 5-year window by any stretch of the imagination. So there's some things that we're going to be affected by, probably, or he is. And
Or actually,
it's-
you are very much in the 5-year window.
Yeah,
Yeah.
we are in this. So,
Yeah.
so that now long ago he sold all his real estate. And all
Okay,
that. So
gotcha.
there's no real estate involved or anything like that.
Okay.
But he does have some funds, that are his, and from what I understand, I mean that'll just have to be eat up for the most part.
Well, if you don't, do you mind if I ask you a few questions? About
Not
it?
at
I mean,
all.
I don't. It's on the air, and I don't want to.
That's-
We can make it fictitious, but just out of curiosity.
Sure.
This is the kind of questions I would ask.
Yeah.
Is he married,
Well, his
or is
wife,
she just deceased?
She's
Okay,
deceased.
so he's a surviving spouse, right?
Yes, that's correct.
And he has no real property, you say,
No.
and it was all sold, so it doesn't matter whether that was 5 years ago or not, because
Yeah.
when you sell it, it's a compensated transfer. So there's
Right.
no,
It was
there-
many years ago, but yes.
Yeah, but there's nothing to do with the 5-year window because it was a sale,
Right.
not a gift.
Right.
And so he's got are his assets pretty much boiled down to financial stuff in a financial institution like bank accounts or
Yeah.
CDs or Edward Jones. I mean, investment account type stuff. It's all reduced to that, right?
Right.
Okay. Now, if that would happen, if he were to go in, okay, we can save a majority of what he owns. Now, when you're single, you've heard me say before, sometimes when you're single and in crisis, okay,
Yes.
there's not a whole lot of pre-planning that can be done at this point if he's already
Right.
having some health issues. A few things we could put into motion, but especially if he had a house, but that's not in the equation. So we could probably save in the neighborhood of 60 to 70% of everything he owns.
Okay.
If he went in tomorrow, if he goes into the care soon,
Yeah.
we can still save a ton of that. So, I mean, what does not have to happen is you don't have to use all his assets and just do what they call spend down and spend on the cost of care until they're all gone.
Right.
That does not have to happen.
Okay.
We can save 60 or 70% of everything he owns.
Okay.
When you're single, there's some loss. And, and basically what we're going to kind of do, or can do,
Right.
is once he becomes eligible, there's a provision under our Deficit Reduction Act that we adopted in 2006 that says an individual can gift away a portion of their funds. Okay.
Yes.
The word portion. And that portion they're going to gift away is in the neighborhood of, and this is all back calculated, but so I don't know what it's going to be until we calculate it because there's several variables, but it usually ends up anywhere from 60 to 70%. Okay.
Okay.
So he can gift away. Let's just use 60 for an easy number. Sometimes the old timers used to call this a half a loaf theory,
Yeah.
but it's a little more than half and half. So he can gift away about 60% of all those assets. Now, as far as it's your grandfather-in-law or father-in-law?
Father-in-law.
Okay, so your father-in-law. Now, well, let me ask one more question. How many children does he have?
2.
Are either of them disabled?
No.
Okay. All right. If your father-in-law, because of what you just described to me, there's nobody he can gift property to that can be exempt from the penalty period you get when you gift something away. Okay. That's why I asked if he was married. If he's married, he can give everything to his spouse and be eligible with the stroke of a pen. Okay.
Okay.
If there was a disabled child, he can direct everything to that person. Mm-hmm. And I don't ask about the other ones. 'Cause the other ones are, is there a child under 21 living in a home or anyone that's blind?
No.
Okay. All right. And so
It's interesting how they have those categories. Those
they
things.
do. That's right. And they're very specific.
Yeah.
They got to fit. If they don't fit, they don't work.
Yeah. Yeah.
And we talked about a couple of them that I do see from time to time. But now, let me ask you this. No, you said he doesn't have a house, so he's living with you.
That's correct.
I was going to go through an exception, what we call the child caregiver exception.
Yep.
And that would be your wife, would be his child. Right?
Yes.
But that requires her moving into his house, not him moving into her house.
Okay,
Yeah,
so
that's
different
one
circumstance.
that's one of the specifics.
Yeah,
So
how about
anyway,
that?
so that won't work. So there's really no one he can gift property to without suffering this penalty period, because if he gifts it away now, he'll most assuredly be within his 60 months if he goes into a nursing home.
Yeah.
I mean, I guess if you could take care of him for 5 whole years before that happens, but nonetheless, what we can do. But this is a strategy we do once he actually goes into care. So let's say fast forward, I don't know, 6 months, a year, 2 years, whatever it is,
Right.
and you're kind of reaching the inevitable decision that he's headed for care.
Yeah.
Okay? And usually the way that works is, I know your wife and it's her father, and she says, I'm going to take care of him. I'm not going to put him in a facility.
Right.
And I hear that a lot. But you finally reach a position where his level of care exceeds your ability to do it.
Yeah.
Now, whether physically exceeds it, or if they physically exceed it and you want to hire people to come in to do it,
Right.
if it reaches a point where either you can't do it physically or you can't afford to do it by hiring other people to do it, you just can't do it. Now, when that happens, your father-in-law is at risk because he's not getting the care that he needs because of whatever.
Yeah.
That's not a very good place to be, because there can be some liability that attaches to that if he would get hurt because he's not getting cared for properly.
Yeah.
And the position the state can take is, well, if you're taking care of him to the exclusion of everything else, then you're held to the standard that you have to. If his level of care is up here, and I'm holding my hand up like this, then you have to give him this much care.
Okay.
If you've only given him this much care, and that you cannot use the argument, well, we can't afford to have somebody in here 24/7, or I can't lift him anymore, I can't physically do it. If you're keeping him at home to take care of him, you are held to the standard of taking care of him to the level of care he needs.
Okay.
And it doesn't happen very often, but when you do that, you're starting to wax the edges of some of our abuse statutes, because they're not getting the care they need, and they're at risk. So and that's how people usually end up there. We just can't do what is necessary.
Yeah.
And so they go to a place where the care is given to them.
Yeah.
So that's what we call crisis. He's actually in care. So when he gets there, what he can do, we want to get him eligible. We want to protect our assets and shift the long-term care bill to the third-party state, which is what the statute requires us to do.
Yeah.
We don't do it because we want the state to pay. We do it because the courts have said TennCare benefits are an entitlement to us. And so when you go into care, you should shift the burden to a third party.
Yeah.
And the third party is the TennCare program, which is what it's for. So
Yes.
some people say, I feel bad about doing that. Don't. That's why it's there.
Yeah.
I mean, it's bigger than what I'm saying, but you don't have to feel like, well, I don't want to do this. I'm not going to mooch off the state or think it's welfare. It is not. It is a program that's designed for this very purpose.
Right.
It's there for you. The courts have said it's an entitlement. You've
Right.
paid for it all your life.
Yeah.
Involuntarily, I might add, which is why it's an entitlement.
Right.
And so in other words, basically what they're saying.
Yeah, you've already been paying
in
for
good old boy Southern languages. You should go whole hog and get what's coming to you. Okay, that's kind of the way it is.
Yeah.
So we have a responsibility to shift it. So now, what does that mean? Well, we put him in care. We want to shift the bill to TennCare. Now, it's an entitlement, but we still have to make him eligible. So we still have to go through the eligibility rules.
Right.
The eligibility rules, as I've said many times, are in 3 categories. Medically needy, which if he's in the home, we assume he needs to be there. And that's a medical call. And they do an exam, a pre-admission exam to determine all that. And so that's pretty much a given. And then the other 2 categories are we got to get him income eligible and then asset eligible. People know the difference between income and assets. Income is like your Social Security and your pension. Your assets are what you own.
Right.
Or what you have. Like if you have a bunch of money in the bank, you've got that. But if you get your $2,000 worth of Social Security and maybe a little pension every month, that usually comes in every month and goes out every month because you're using that to live off.
Right.
That's what income's for. So income is easy to qualify for, okay? Even though we're an income cap state, which is capped at $2,742 a month, if you make more than that, we can still fix that. That's a pretty easy thing to fix. Where we spend most of our time is now let's get him asset eligible. So let's just use a number, nice round number.
Okay.
Of $100,000. Let's say, his assets are $100,000 in a bank, it can be any form. A CD,
Sure.
401k, IRA, those tax-deferred funds.
Okay.
Like a managed investment account, like Edward Jones, Morgan Stanley, Raymond, there's a bunch of them.
Right.
Or an annuity or something. Okay.
Yeah.
So he's got these assets. Let's say it's a nice round $100,000.
Okay.
Easy number to talk about on the radio.
Right, exactly.
And so what we can do is we can gift away, let's say 60% of that. Now, he can't gift it to anybody without suffering a penalty because all the penalty-free exceptions don't apply. Okay. So he can give it to your wife.
Okay.
Which is a child. Or actually, give it to anybody, but let's say we want to keep it in the family. Okay, so you give 60% of that.
Okay.
Now, what the Deficit Reduction Act says, we're allowed to gift away a portion of our funds and retain a portion. So if we give away 60%, the retained portion is 40%.
Right.
And the retained portion, we can purchase an annuity to pay that's back calculated to pay the exact cost of care for the exact length of time, the penalty period that was triggered.
Okay.
So let's just use those numbers and just say 60% of $100,000 is $60,000.
Right.
So if we divide that round it off to 7,000, okay, we're going to come up with something in the neighborhood of 8 to 9 months. Okay.
Okay.
Is going to be the penalty period. So let's just say 8 months. Now, if he gives it away, and we've triggered this penalty period, which is going to be 8 months, and so we're going to retain the $40,000 that he didn't give away, and we're going to purchase a Medicaid compliant annuity. The Medicaid compliant annuity, and I'll talk about what the compliant aspects are, but this annuity, now the way we calculate this, we have to know his income, we have to know his cost of care per month, and then we can back calculate what the gift can be so that what's left over will pay the exact amount of his cost of care after his income goes in there for the exact penalty period that the gift. So it's a big math problem.
Sure.
And I actually have I generated a program that does it. Okay. And sometimes we even have to throw in, if the annuity offer, if it's a long annuity, we can throw in some interest that it earns and stuff. But anyway, so let's just say it creates an 8-month penalty period. What's going to happen is the $40,000 is designed to pay for the 8 months. Now, somebody will do the math and say, well, $40,000 divided by an average of $9,500 doesn't pay the 8 months. Okay, well, there's other factors. Because he's single, all his income goes to the cost of care.
Yes.
So if he's got a $9,000 bill every month and he's got $2,500 worth of income every month, that goes to the cost of care. So already the $9,000 is down to $6,500, right?
Yes.
Okay, and then there's other factors that come into that. Some of it's the TennCare payback rate.
Right.
And that gets pretty complicated, but nonetheless. So it's designed to do this. So what happens is he goes in nursing home. We do this. He writes your daughter a check for $60,000.
Okay.
Then he takes the $40,000 and buys the annuity. We fill it the very next day, or the very same day. Doesn't matter.
Yeah.
So now let's look at your father-in-law's financial status at this moment.
Okay.
He has nothing.
Okay.
He either gave it away, coupled with the spending of the remainder on the annuity, he doesn't have any assets anymore.
Okay.
Well, in this equation, we save $2,000 because he's allowed to have $2,000, right? Everybody's heard about that.
Right.
So, but let's leave it out of the equation for now. But basically, we would be dealing with 98,000 instead of 100 because two would reside with him. But that's just to have some what we call walk around flash, you know.
Right.
There's not much to do anything else. But anyway, so when he does this, he's pretty much broke.
Yeah.
Right. He's with a combination of giving it or spending it, it's gone.
Okay.
Which is exactly what the Deficit Reduction Act told us we can do. We can retain a portion and spend a portion on an annuity.
Yes.
Now,
Okay.
so now we file the 10-care application, okay?
Yeah.
And on the 10-care application, it's going to say, second or third to last question says something very straightforward like, have you ever given anything away for less than market value? And the answer we're going to put there is yes. And they're going to say, okay, what'd you give away? We're going to say $60,000. What'd you do with it? I gave it to my daughter, right?
Yes.
And they're going to say, well, that's a gift. And we say, yes, thank you, Sherlock. We know that. We knew it when we gave it to the daughter, okay? But appreciate the input. Yes, you're right. Gift. That's absolutely a gift. They're going to say, well, there's going to be a penalty period that goes with that. That's right. Would you like me to tell you before you figure it up how long it is and how much it's going to cost? And so eventually the goal is they're going to look at your your father-in-law, at his assets, and they're going to say, well, tell us about his assets now, as of the filing of the application, which is after what we just did.
Right.
It could be the day after.
Yeah.
And they're going to say, well, he has less than $2,000 of countable assets, and that's all he has.
Yeah.
That's right. We made it that way. That's exactly right.
Yeah.
So he's eligible. Yes, we know that. Thank you. We just need you to say it because you're 10-care, and
you have to put the approval on it.
And they're going to say, they say, well, you gave away this money. When did you do it? Yesterday. Well, that's within the 60 months. Yes, we know. But he's eligible now. You got the application on, we did all this Monday and Tuesday, now it's Wednesday, you get the application. He is eligible now. And they say, well, that's right. So here's what, they say, but he has this penalty period. So here's this magical language in the statute that says if you are eligible, otherwise eligible, but for the penalty.
Yes.
That's what we're trying to achieve. And so that's what we've done. They're going to say, you know what? We looked at your dad's application, or your father-in-law's application, and he's eligible. We are ready to pay. But unfortunately, we're not going to pay for 8 months because he gave away some property that if he'd kept it, he could have paid us. And it's like, that's right. So we're going to impose an 8 month otherwise eligible, but for the penalty period means they're going to say, we approve him. And at the expiration of this penalty, but for the penalty, at the expiration of the penalty, we will start paying his bill because he is otherwise eligible, but for this block of time that we're not going to pay. Mm-hmm. So when they're not going to pay, we have to do something about it. So we're going to have to private pay. So we have this annuity. It's a single premium, an immediate annuity, which means it's going to start paying immediately. Okay. We sent them a lump sum, single premium, $40,000. Yeah. Bought the annuity. They're going to start paying that right away. And so when that comes in, every month this annuity is going to last 8 months. It's going to pay us once a month it's going to pay us like $6,500. I'm using the numbers that we have. I can't do all of them in my head. But they're going to get an annuity payment every month for 8 months for $6,500.
Yes.
And then we're going to take the income and we're going to send it to the facility and pay. And so the facility's going to be happy as a clam at high tide. 10-care's happy as a clam at high tide because they're saying, well, we're not going to pay if you're going to give your stuff away. And you're paying on your own until we're clear of what you gave away. Yeah. And so we're going to pay for 8 months. At the end of the 8 months, we're already approved. So at the end of 8 months, on month number 9, 10-care will start to pay.
Okay.
Right. Now, for the rest of his life, as long as he lives in a nursing home, let's say, every month what's going to happen, there's no longer an annuity, but every month his income's going to go to the cost of care every month for however long. And now, what is the end result of all that? We salvaged $60,000 of that $100,000 by giving it to one of his children.
Yeah.
And that's hers. And that's the end of it. You know what I mean?
Okay.
And so compared to what you said in the first place is I guess all that's just going to get spent on the cost of care, which is a better option to be in.
Oh, yeah.
I mean, so it's a common strategy, especially with single folks. Because, you often heard me say sometimes when you're single and in crisis, there's going to be some loss.
Yeah.
Okay? And this is why. We don't have anybody. We have to give it away to keep it. But in order to give it away, we can't give it to anybody unless, a goal is try to give it to somebody that we don't get a penalty for.
Right.
And when you're married, we have somebody, the spouse.
Right.
Unlimited gifting to the spouse. I mean, give them $1 million and no penalty period.
How about that?
So, and keep it in the family. But when you're single, we've lost a few options.
Interesting.
That's why crisis planning, we can save a lot of money. Married couple, we can save it all. Single person, we're not going to be able to save it all. So that's why it's kind of good to do some planning ahead of time. Because if we can put some of that property in asset protection trust long before they get in a position where they might be headed there, then we can save it all.
Right.
But even in crisis, because so many people say, my father-in-law's in a nursing home, they're going to get everything. It's super expensive. It's just going to all be gone. We're just SOL.
Yeah.
And it is not that way. I mean, we have rules, and these aren't my rules. This is Stan Pierchoski, first 14, when I make it up and do it. I told several times, this is one of the strategies allowed us in the Deficit Reduction Act of 2005. Tennessee adopted that in 2006. They're in full force and effect. We use them. We do them all the time, these Medicaid-compliant annuities. Now, let's talk about what does it mean to be a Medicaid-compliant annuity? Because if you went out today and bought an annuity, so you and your wife said, we got some extra money, let's buy an annuity, and it'll pay us back in our retirement years, kind of like what people do. Well, that one's not Medicaid compliant. So let's talk about what does Medicaid compliant annuity mean. Let me preface it like this. To be a Medicaid compliant anything, you got to think of it this way. Put yourself in TennCare's shoes, and you got to think like this. How is somebody going to screw us out of the money that we could get paid for a care?
Yeah.
Okay, I don't know how else to put it, but if you think like that, it all makes sense. Okay, so TennCare says the Deficit Reduction Act says we will let you do this. Now, the Deficit Reduction Act was a federal act. The individual states adopted it. Okay,
right.
And so when we adopted it, Medicaid compliant means this: once you do it, once you buy the annuity, it's got to be irrevocable and unassignable, which means, and now let's put ourselves in TennCare shoes, okay, and see, why would it have to be irrevocable and unassignable? Here's why. TennCare says you do this, you gift away a portion, you buy the annuity, then we'll grant approval. What we don't want is after we grant you approval, you go cash the annuity out, and now you got the $40,000 of assets and disband. You know what I mean? So they say we'll let you do it, but if you do it, that's the end of it. It pays back. The annuity has to pay out. You can't go cash it out. Okay. And that's one of the things. One, it has to be actuarially sound. I think I talked a couple of weeks ago about some folks we were dealing with that were like 96 years old. But how old's your father-in-law?
He's 92.
Okay, so if we went to the actuarial tables, thank goodness the government has tables that tell us how long we're going to live.
Yeah.
I mean, God bless them. I kind of always wondered about that. But anyway, so it's actuarial statistics, right?
Yes.
So we go and look under the column of male and find 92 years. We go across with our finger and see what's life expectancy.
Yeah.
And for him at 92, it's probably going to be something like, I'm going to say every bit of 5 to 6 years. Okay. Yeah. So 48 to 60 months. We're talking about an 8-month annuity, so we're certainly actuarial sound. What they're saying is, your dad's 92, we can't enter into a 40-year annuity, right? Okay. You've got to be actuarially sound. Cannot exceed his expected life.
Now I see what you mean.
So, and this one, nowhere near it, 8 months, right?
Yeah.
Now, if your father-in-law had a large amount of money, you can see where that penalty period gets bigger.
Right.
And we may actuarially sound could be a concern, but even then there's some things we can do. But this one's no problem. We're there. Now, the other thing for Medicaid compliant is it has to be equal payments every month. There's some annuities, in other words, you can't get $10 a month and then at the end get this giant balloon payment or something like that.
Okay.
So it's got to be equal payments every month. So those are the Medicaid compliant aspects. Not hard to accomplish 99% of the time. Like I said, I had one where the person was 96 years old. Their life expectancy was 34 months, which is just under 3 years. And, does that sound realistic? If you're 96, you've got 3 more years to live.
Mm-hmm.
I don't anyway. Actually, it goes up to 104, and that still has some time to.
Really?
It never goes to 0.
It's amazing.
They just stop going above a certain age. I think it actually goes to age 119.
Really?
The table. But anyway, so if you're up there in age, it can be an issue. And if you have a large assets, our penalty period could exceed, and then we have to cap it at the actuarially sound.
Yes.
So we can have a penalty period longer than the annuity. Okay, but when you're 96, it's kind of a good risk. But anyway, so that's the Medicaid compliance. So if we do all that and do it the way they say, so like I said, none of this is my idea.
Right.
I'm not smart enough to think this stuff up, right? But we do it, and now. Then when we application, they're going to say, "What'd you do with that $60,000 or the $40,000?" I
Yes.
said, "Well, they say, I see your bank account spent $40,000. What'd you do with that? We bought a Medicaid compliant annuity. Can we see the annuity contract to make sure it's Medicaid compliant? Certainly. Here it is.
Absolutely.
Here it is. It's got all the stuff you need." They come to the inevitable conclusion: okay, everything's wonderful. You are otherwise eligible, but for this penalty that gift created. And
Yes.
off we go. Now we're set. Now we just sit and, so what's the end result of that? We salvaged 60%. What's the downside? Well, we lost 40% because
you didn't lose it all.
We kind of have to private pay for this time.
Right.
But compared to doing nothing
Yes.
and paying the full amount,
Yes.
okay, there's the full amount, the 10-care rate. There's like monopoly money going on there, but you have to pay the full $9,000 a month
Yes.
on average. You're going to exhaust that $100,000 pretty rapidly.
Yep.
And there's nothing left. I
Yeah.
mean, the difference is night and day.
Yeah,
And so,
absolutely.
But a lot of folks just don't know what's out there, which is why I'm on the radio and do what I do and try to
Yeah.
tell folks, listen. Now, is that the strategy that works for everybody? No, but it's just one of them, and it's one of the ones we use often. But there's many other strategies that we use that work depending on the circumstances. That was something that worked great for your father-in-law.
Well, somebody who's in that position, not necessarily my father-in-law, but somebody who's in that position. Well, you mentioned something a while back that just that hit my memory, which was I thought was kind of interesting. They can own a car, or they can own a vehicle.
That's right.
So rehearse that for me again.
Sure. Your father-in-law can own one vehicle regardless of value.
Yes.
Now, we have to say it's his primary it's his primary mode of transportation, and it
Yeah.
is. Now, if he's in a nursing home and can't drive or doesn't drive,
Yeah.
that's not part of the criteria. You know what I mean? He's entitled to a vehicle regardless of value.
Yeah.
So if you got two, one's an old beater and the other one's a pretty decent car, we'll get rid of the old beater and keep the good one.
Yeah.
Sometimes this doesn't happen often, but here's the theory. I think I've only did it something not even to much of an extent, but I only did it once that I can think of. But here's the theory: suppose we needed to move some money.
Yeah.
Now there's other things you can spend money on. You can do home improvements to the house. Okay. Even if you're not, you can put ramps in or something if you got a wheelchair or something,
Yeah,
stuff
okay.
like that. Yeah.
Okay.
You can, and the category for home improvements is just reasonably necessary.
Yeah.
Okay, so if you're going to trim the walls in gold wallpaper, that's probably not reasonably necessary. But if just about anything else you do,
Yeah.
new counters, new appliances, ramps, better floors, things that are, it's not hard to get into the reasonably necessary category.
Okay.
You can pay off debt. That's not always a fun thing to do, but if we're trying to get eligible and we got a little too much money, that's the place it can go.
Okay.
You can just like I talked earlier we talked on an earlier show. You can just take money, which is a countable asset, and buy tangible personal property, which is a non-countable asset. So, buy clothes, buy consumables, buy new appliances, like I was talking about. Those aren't home improvements; those go along with home improvement, but you're buying things. So
Okay.
when you take money and buy a new refrigerator, that's not a countable asset. The refrigerator's not. The money was.
Okay.
So we're making a simple conversion by a fair market exchange by buying a refrigerator, buying new stoves, upgrade everything, spend money.
Okay.
Now, this is ways to move money and get something out of it, which is something we do if it's necessary, but wouldn't just go buy a bunch of stuff just to get rid of money. There's other ways to get rid of stuff. But if
Okay.
it's needed, we want to do that.
Okay.
That kind of thing. So now the car is the same thing. One car, regardless of value. So if you don't have a car, my thought is if we need to, if there's a reason to, if the finances make it necessary, we can buy one.
Okay.
Now let's just go a little further, okay?
Okay.
If you buy a car, would you buy a $5,000 beater? A clunker. Well, I mean, let's go back to the language of the statute. One vehicle regardless of value.
Yes.
I don't know, maybe we want to buy a Tesla, right? Or an Aston Martin.
Yeah.
$300,000 car. I don't know. The language says one vehicle regardless of value.
Yes.
I mean,
Yeah.
the value is wide
Interesting.
open.
Interesting.
I didn't write it. Okay. I
understand.
didn't make the rule. I'm trying to figure out a way to make it work to our advantage.
Yeah.
Now, probably would never present itself to buy a $300,000 Austin Martin.
No.
Right?
No.
I do have a client that has one of those, by the way.
Do you? Really?
He's promised to take me a ride in it one of these days, and I have not yet. But you see the theory.
Yes.
And you see the thought process.
Yeah.
This is what I do. Okay, this is what we do to get people eligible. We have rules. I didn't write the rules. The rules are there. Now, actually, the rules are a lot less than they used to be before the 2006 Reduction Act, but they are what they are.
Okay.
And so there's ways to make the rules work in our favor. Now, why would you buy a Tesla for grandma who's in the nursing home, can't drive, doesn't have a driver's license? Well, it is something she has that's going to be a non-countable asset. And what's going to happen to that Tesla when something happens to grandma? I mean, it's going to go to a family member, right?
Right.
That might be a reason why.
Yeah.
I mean, again, you see where I'm going. I'm kind of being a little bit
Sure.
on the extreme end.
Yeah, but the obvious answer is, it's a place to put money where it's not countable asset.
Suppose if you need a car,
Yeah.
get one. Don't buy an old beat up clunker. Get a decent car. It doesn't have to be brand new necessarily, but it could.
Yeah.
But get one that's certainly going to be reliable. Suppose you need this car to go visit grandma.
Yeah.
Get a decent car. It's not going to hurt a thing to spend the money.
Right.
And the car is going to preserve some value after death when it goes to the heirs. So stuff like that. When you buy home improvements like appliances, there's not much market value in those later on.
Right.
That's all part of, if you have your own home.
Right.
So, I mean, is that, you said about the
Yeah,
vehicles?
I'm just curious how of course, every circumstance is always different, I guess, and everybody has to you have to look at their own circumstances, their own financial status, and all their assets or lack of, and see how you can use the system as the laws are set up, like you've talked about. I've learned a lot. I'm going to be a lawyer before this is over.
Well, what kind of car does your father-in-law want?
Yeah, what kind does he want?
Well, we still have to buy it with Dad's money. In other words, if he can spend his whole $100,000 that we're using as an example on a car, he is instantly eligible. We have accelerated his eligibility by purchasing the car. Okay. Now he has less than $2,000 of countable assets. And he's got the car. Now, I mean, is that the best strategy? Probably not. But you see how it works.
Yeah, I see.
If the shoe will fit somewhere, then we have these tools to work with.
That's very interesting.
But now we're on that level, and we kind of getting 3/4 of the way into the hour. Of course,
I jumped you off probably nowhere near where you were going to talk about today.
This is going to be another hodgepodge kind of day. But I was going to talk about something, we haven't given out the phone number if anybody wanted to call.
Yeah, that's right, 766-9393. If somebody wants to chime in on this conversation, you sure can.
I was talking at the same time, so 766-9393. Don't call if you want to figure out how to get a Lexus. a Tesla or something like that. But the other thing that comes up when we deal with people, when you file for TennCare, you have to declare an intent to return home.
Okay.
And sometimes people don't have a home, like your dad. So, your father-in-law. So if your father-in-law ever went in and we filed an application, we would declare an intent to return home because he may come home someday, right? Yeah. But the main reason we do that, and people say, well, he's in the nursing home, he's never coming out.
Yeah.
Why do we there's hope he's coming out? That's not really what it's about.
Right.
When you have a home, we talked about this before, but it can be talked about more.
Right.
And that is when you have a home, it is a countable asset, right? But it's also an exempt asset. And so what they'll do is they'll say, when I say home, I'm talking about the primary residence.
Right.
There's another category called other real estate. So if you have a home and then you have a piece of property across town, only one's the primary residence, right? And anything contiguous to it. So it could be 1,000 acres if they're all touching.
Yeah, exactly.
So you got this primary residence, you can exempt that. And the exemption means you just take it out of the countable assets column. And when you do that, now that's not my favorite strategy because that makes it subject to estate recovery after death. But in order to make it exempt, sometimes we'll exempt it up front and then we'll deal with it right after approval to protect it from estate recovery. That's my strategy. But to get it exempt up front, you have to have it's part of the making the asset excluded or an exempt asset. This intent to return home is what's part of that. That's the whole purpose we do that. If you claim an intent to return home and you do have a primary home, now we can exempt the home to get eligible.
Yeah.
Now I don't ever want to leave it exempt That's a pretty common strategy. A lot of times people go to a facility and the facility will say, "Oh, your home is protected," and although that's not the right word, it's you can make it non-countable for now,
Yeah.
or not non-countable. You can exempt it for now, which means when they're figuring up if you're eligible, they will not include the value of your $300,000 home.
Okay.
Now, if a $300,000 home is a countable asset, how are you ever going to be eligible if you have to be below $2,000 of countable assets?
Right.
You got 298,000 too many, right?
Right.
Well,
Right.
they'll let you exempt the primary residence, so we take it out of the countable assets column and put it over here and exempt. The problem with that is if you don't do anything else, at death, they're going to exercise estate recovery, which means they can go after anything in your estate. Now, remember the house. It's
Yes.
still there.
Yes.
You still own it.
Yes.
They just didn't use it against you for eligibility purposes.
Right.
But they're coming after it in estate recovery.
They'll recover it later.
So what we do is we exempt it so we can get eligible real fast. And then after we're approved, now we're going to transfer ownership to the spouse, or because now we can do that.
Yeah.
And now at death, under our rules, our estate recovery rules, we have a hybrid state. And I'll talk about that someday. But if you have an interest in the property at death, it's in the estate. Even so, if you have right of survivorship, where all ownership vests with the survivor at death, they're taking a position that's an interest at death. And so if it passes by right of survivorship, it's in the estate. So what we want to do is during life, transfer all right, title, and interest to our spouse. And we do that post-approval. Now, at death, we have no interest in the house. So it's escaped estate recovery, at least for that spouse.
Okay.
I'm not going to get complicated and say, now what about if the other spouse goes in? Because that does get complicated.
Yes.
Doesn't happen often, but it's possible. So, we're making this asset exempt to get it out of the way. Kind of lost my train of thought as to what I was honing in on there.
Okay.
Oh, I know what it was. So in order to do all that, we have to do this, claim this intent to return home.
Oh, okay.
So we always say intent, even if you don't have a home. People ask me, that doesn't make any sense. I say, well, it does, because you could have one.
Yes.
So we want to preserve the ability to exempt that home if that's the case. So that's why, there are a lot of things that don't make sense on the surface, but when you dig into them, they kind of have a reason, and that's one of them.
Yeah.
So let me, we come up on the end of the hour, kind of. We got about 10 or 15 minutes, but this is state recovery. I'll talk about this more because I could talk about this probably for a couple of shows, because the estate recovery is what I call a sleeper. It's something that happens after death, and most people don't even know it till they get the bill, and it's way too late to do anything about it.
Yeah.
And you're not told that by most folks. And I think you're not told that because they don't understand it. They think it is a protected asset.
Right.
And the word protected is where I have an objection to that.
Yeah.
It's not protected. It's a deferral.
Yeah.
It's going to happen. They're just not going to do it now.
Yeah.
And I often said they'll come after it after death. And now there's a few exceptions. I said, God bless them. They will wait. If you have a spouse living there,
Yes.
they will wait till that spouse dies before they come and take it. So there's some exceptions there, but they are going to come after that house. And they're entitled to the cost of care that they paid, and the house is either going to cover it or not cover it.
Right.
But that's all they can get if the house is worth more.
Yeah.
The estate will get the overage, but nonetheless, I'm not a big fan of exempt. I'll exempt something to get eligible, but we won't leave it exempt
Okay.
because they're going to get it.
Yeah.
So what we want to do is protect it and give it to the kids or the heirs, which is
Right.
usually what the people would do if they weren't in the facility anyway.
So is that when you look at transferring something that's exempt into some kind of a trust?
No, I'm talking about the crisis planning.
Okay,
If
the
you
crisis.
if you put it in the trust, it's protected by the trust, and we never have to deal with it again.
Okay.
Yeah,
Okay.
you've already assigned your interest in it. It's in the trust.
Okay.
And so, in other words, when you put it in a trust, we talked about giving up access to principal, right? Now, remember I said you still could get at it, exercising the certain rights of the trust, but let's say once we put it in there, we can't get to the principal. So if somebody would say to you, they wouldn't, but if you put somebody in a facility and the facility or somebody says you need to sell this house and use the money or give us the house for your payment stuff, its response is I don't have the authority or the capacity to give it to you. I mean, if I had a pen and paper, I couldn't. If I wanted to give it to you, I can't do it. Mm-hmm. It's not mine to give. It's in this trust.
Right.
That's what protects it. Because remember with the old adage, if you can get access to an asset, so too can your creditors.
Right.
So if I can get at it, they can get at it.
Yes.
But it's in a trust, we can't get at it. Now, it doesn't mean we can't use it, doesn't mean we can't control it, and doesn't mean we can't sell it and buy a new house, and it doesn't mean we couldn't get at the money in that house if we needed to. We can. We just have to do it a certain way for the thing to work. So that's the whole concept. But this estate recovery that I want to talk about is people don't know it's out there until they get the bill.
Yeah.
And then it's like, okay, I have to pay this back, all this money that they paid for grandma?
Yeah.
The answer is yes. And they do it through estate recovery. Now,
Okay.
we have estate recovery originally is in two forms. Either standard, which means they just go after what's in the probate estate, or expanded, which means they can kind of go after just about anything. Okay? And the states decide.
Yeah.
Tennessee's a standard one, which means they just go after what's in the probate estate, which means if you had a revocable living trust and put your house in it, they can't ever get it because those things are probate avoidance, right? But that's not exactly what Tennessee is. The courts have modified a few things over the years, and we have become what they call a hybrid. We're not standard. Now we're not all the way to enhanced, but we're somewhere in the middle. And in the middle, based on a court decision called In Re, the Estate of Smith, back in 2006, where the court said, if you, as far as real estate is concerned, if you have a interest in the property at death, it's in the estate. Okay, so those are the marching orders. That takes it out of the standard realm. But there's things we can do to kind of get it back there. But now we have to do it to make it work, rather than just be in the law that they can't go after with anything outside the probate estate. So if it's outside the probate estate, any probate avoidance technique on property would shield it. But they've decided to expand that a little bit.
Yeah.
I'm glad they don't go to the expanded estates, because the states that have expanded estate recovery, everything's accessible to them.
Yeah. Yeah.
And the states don't really want to do estate recovery. They're required in the Medicaid Act to do that. As a matter of fact, back when they required that in the Medicaid Act, that you must have an estate recovery program, West Virginia sued the federal government. Said, we're not going to do it. We don't think this is right. We don't think it's fair. We're not going to do it. Went to the Supreme Court, and the Supreme Court said, in long story short, they said this is a federal act. If you're going to participate in the funds they give, they dictate the terms. So there's nothing unconstitutional about it. So if you have to do it. So West Virginia didn't like it, but now they have to have an estate recovery program. And actually, there are two states that claim to have abolished estate recovery. Now, I wonder how they do that when it's a mandatory part of the act. And here's why they abolish it. They say it costs us too much money to do it. In other words, we spend, for round numbers, we spend $10 million a year in administrative costs running the estate recovery program of our Medicaid system in this state.
Right.
But we only ever recover $8 million. So we're going $2 million in the hole every year trying to recover because we don't recover enough. So it's a losing proposition. So they say, we're abolishing it. We're losing money. Now, I wonder how they can do that. I don't know that that's been finalized yet because it's mandatory from the federal act that you have a estate recovery program.
Really?
Maybe I'm not sure. They might have created a waiver program. I don't know. But there is an act before full Congress now to abolish it everywhere. I think it has zero hope of being successful because, when you have TennCare or any state has this program, it needs to be funded. This is one of the main ways they fund it.
Yeah.
Okay.
Yeah.
Now, you might say, well, if they fund it, what we're doing is planning to help people not have to pay money in estate recovery. Yeah, that's exactly right. But again, I know it needs to be funded, but I didn't write the rules that shows ways that they can't get property in estate recovery.
Yeah.
I'm just doing what the law says we're supposed to do.
Right.
Shift the burden off of us to a third party.
Yeah.
And the third party is the state. I mean, I'm just being a good servant and following the rules, right? I mean,
that's the rules.
And again, I don't ever do anything that's outside the rules. We had a seminar a while back, and somebody raised, we're talking about the Asset Protection Trust.
Right.
And it's a grand tool. And when people hear about it, they kind of light up and think,
Yeah.
Really? We can do that? That's pretty great. That's cool.
Yeah.
And somebody was there, it was a couple, and the wife raised her hand, and she goes, how is it that the government doesn't know about this? And I said, when you say that, it sounds like you're sort of implying we're doing something we're not supposed to do, and it's under the table or something shady. And I spent a fair amount of time on that question. Listen, everything we do is what they tell us we can do. They meaning the state of Tennessee and the TennCare Act.
Yeah.
as adopted from the Medicaid Act.
Yeah.
So we're playing in their sandbox. And when we do it, it's full disclosure.
Well, the people who made those laws, a lot of them are attorneys themselves and have assets themselves, and they made a way so they could protect their own selves as well.
That is a connecting of the dots that is very astute of you. You are, I don't want to say that's the reason, but it is a reason.
It is a reason.
People benefit from these things, and some of the people that benefit are the people involved in it. So, but it's also there to help us. If they had a system that said, just when you die, we're just going to take everything you own.
Yeah.
I mean, you have a rebellion. I mean,
Yeah,
you know what
exactly
I mean?
right.
It's in our best interest for them to do that. So when somebody says, how does the government know about this? I told you earlier, when we do something, we disclose it in the application.
Yeah.
We see you have a house.
Yeah.
What'd you do with it? Well, we put it into an asset protection trust. This is the thing I was talking about when,
Right.
when they asked the question. When they said, how does the government haven't found out about this? What'd you do with the house? We put it into an asset protection trust. Okay. When did you do that? 6 years ago. Oh, I see. So it's beyond our ability to do anything about it because we can only do anything for 60 months, which is 5 years. That's right. It's past the ability.
Right.
Okay. So can we see a copy of this trust? Sure. Here's a copy right here. I'll send it to you. We want to look it over. Okay, look it over. They won't find anything wrong with mine, but they'll look it over.
Yeah.
And then they'll have to come to the conclusion that here's the rule. Looks like Pierchoski estate law followed it to the T.
Exactly.
Everything's good. So, these assets are protected. So how is it the government hasn't found out about this? The government wrote it.
They wrote it.
They're the first ones that knew about it. Now, they don't talk about it. If you call them up, they don't say, hey, listen. If you call 10K, they say, hey, look, your father-in-law's got a ton of assets.
Right.
Here's some ways you can save all that. No, I mean,
Well, the bureaucracy that runs that, they didn't invent it.
That's right.
The lawmakers invented it.
Mostly they don't understand it. They can't explain it. But, let's think about it this way. During the eligibility process, if you come to me and say, hey, let's get my father-in-law eligible, my job is to get him to pay as little as possible and get the state to pay as much as possible, right?
Yeah, exactly.
What's 10Care's job? The exact opposite.
Yeah.
They want to get the private person to pay as much as possible and get the state to pay as little as possible.
Yeah.
Okay, so that fight, the arena of that fight, are the eligibility rules of 10
They're in the rules, yes.
Yep. And they pan out the way they pan out.
And both sides have to use the rules that they're given.
That's right.
That's it.
Right.
That's it.
And it's usually when we deal with them, there's no hard feelings on their side. They just want to make sure it's done right.
That's right. Well, we're getting close,
Yeah.
and we need to make sure people know how to get in touch with you and where you are and what's going on next
Certainly.
and all that kind of stuff.
Well, here's how you get a hold of me at Pierchoski State Law, Pierchoski Elder Law.
Yeah.
You can call my office at 931-363-7222. You can go to my website, which is Pierchoski Estate Law at gmail.com, whatever. But you can go to it easier by just typing in estateplanstan.com
Yes.
and take you right there. There you can see my calendar or get the phone number if you miss it, or you can email me a question to get a hold of me. You can see my calendar, and on there you'll see that the next seminar coming up, it's not local, it's up in Franklin, but it's at a place called Suite 501. It's just a little south of the actual Franklin town, but nice little venue, a little limited, it only holds about 50 people. And that's going to be January the 13th, which is a Saturday. So we'll do that at 10 o'clock up there. If you want to come to that, that's great. It's not that far of a drive, and it's worth coming. It's a nice little venue. It's just somewhat a little bit limited. So if you want to come to that, get on the RSVP list, because 40 to 50 is usually about the head count on these things. So we could run out of space, and I'm not sure what I can do up there. I think I can probably bring some chairs out and chink them into the gaps, have a place to sit, and we'll do that. But hopefully I won't have to have a waiting list or something. But anyway, so give us a call, if you want to come to that, or if you want to talk about anything else that we talk about.
Sure.
We'll set up a meeting. We'll set up a 15-minute phone call. We'll discuss it. I'm more than happy to help out. I got to know the facts. You got to tell me the story for me to do the evaluating and come up with what may be a plan or something like that.
Right.
So, in this radio show and all the other radio shows I do, I always have like a byline that says, doing nothing gives a predictable result.
Yeah.
And that's where you don't want to be. I guess doing nothing's a choice, just not the best one that's out there.
Not the best one.
Yeah.
That's right.
So anyway, that's great. It's always a pleasure to be here. I always like talking about it.
Yes, sir.
It's fun. It's thought-provoking. And you ask the greatest questions.
I've certainly learned a lot.
You really do.
I've learned a lot, and I'm still learning. And so in every week, I'm like, okay, now I'm thinking. I got it.
Coming up in June, we'll be doing this for a year.
That's
And
right.
so maybe it's
That's
time
amazing.
to give you a little.
I made it a certificate.
Maybe it's time we give you a little bar exam. Okay,
right.
a little estate planning bar exam.
Stan Pierchoski, everybody, Pierchoski Law and Estate Plan Stand. Look him up, estateplanstand.com. Thank you, brother.
Thank you.
A meeting with the Palestinian president. I'm Dave Anthony, Fox News. For National Security Advisor Jake Sullivan in the West Bank.